Any mention for unlisted matter? Any mention for unlisted matter? From the main list, item number 1.
Mr. Khan, I hope you're still old-fashioned to read newspapers.
Yesterday's paper, Your Lordship, yes.
Yes. Because the younger ones don't read papers anymore. They only have their phone. But yesterday's papers, despite the repair, if that's the condition, then what's the repair?
Absolutely, Lordship. But Lordship, we filed an affidavit today also. Status report, Lordship.
There's a status report, but then either that picture is lying, it's of somewhere else, or if that is the state, then the status report does not mean anything.
Lordship, the top bitumen, Lordship, that is still the work is under progress. So after the newspaper report, Lordship, we have contacted them.
And the heavy rains have not yet started.
Absolutely, Lordship.
And bitumen, you and I both know, is water soluble.
Absolutely, Lordship.
So it's going to dissolve. So it's going to be prepared in such a way that at least the road remains motorable during the monsoon.
Absolutely.
We can't say trucks, you wait, let monsoons get over, after that we go.
Absolutely, Lordship.
There must be some solution. There must be stretches where, the water falls on the mountainside and goes. There are many stretches in hill areas where the water takes those are concretized. Those small stretches have to be concretized. Concrete will cost you probably 10 times as much as, if you make a metal road. But those stretches have to be concretized. It's as if you're constructing a bridge.
Lordship.
There's water flowing below, you have to construct a bridge over it. It's exactly like that. Exactly. There's water flowing on the road. Now, these are not for us to say.
Absolutely, Lordship is correct.
Not for us to say. A, we are not experts and we pretend to be experts. B, we want at the end of the day for the cost. If the road is bad, the cost to the state is much more. You're penny wise, pound foolish.
Absolutely, Lordship.
At the end of the day, you see how much of fuel is being wasted. If cars travel where they can't, you would go on the fourth gear, they have to travel on first and second gear. Yeah. Look at the colossal waste to the nation on the fuel cost. Fuel, time.
Absolutely.
Ask someone responsible to just go visit the place. Visit the place, talk to him directly, and then you tell us, you satisfy us. This is where we have to go a little bit out of the way.
Yeah, absolutely.
Beyond our call of duty.
Absolutely, Lordship. Lordship is very.
Please do that.
Lordship, yes.
Because find out which stretch the pictures are from. It's a small stretch. It's a 7.9 kilometer stretch.
Lordship, yes.
Between Tadlashkaid and that Mimintudu.
Mimintudu, Lordship.
Yes. It's less than 8 kilometers.
We'll talk to the additional chief engineer, Lordship, yes.
And I'll go there next weekend.
If my Lord permits me to make a small submission. Lordship, just last week, we have taken some photographs. In fact, Joy Bypass, last week, my Lord, submissions was made, and we are also happy that they've carried out the construction work. One may kindly see, not even 2 days, one may kindly see the condition of the road. We have taken the photographs, Lordship.
Show it to Mr. Khan. Let him take steps. He's understood. He's not denying. He's not
denying.
He's not denying. He's understood.
The Joy Pass, my Lord, which was my Lord, repaired just last week, Lordship. Not even 2 days. One must see the conditions. Just on record, my Lord, may kindly take this photograph on record, Lordship.
Take it on record. We are giving him some.
It's unfortunate, Lordship.
We'll take it up next Tuesday. A status report has been filed.
My Lord.
Yes.
As far as the national highway is concerned, my lord.
The bypass is not your problem.
No, my lord. But then throughout on the last occasion, certain photographs were given to us, and our project director and all the officials, they have personally visited, my lord. And it seems my officers, they are saying that 30 days time will be required for the contract to be allotted, and thereafter by the end of June, my lord, we are expecting that the considerable progress will be made in the repair work.
Which stretch?
That NH is around 8 spots they have highlighted, my lord.
Where?
In the National Highway 6, my lord. So,
National Highway 6, which area?
my lord,
Between where and where?
my lord, it is in the village of Lumsnong village of the National Highways, my lord. And Lumsnong to Malidar. So, my lord, the National Highway authorities, they have already
That is
looking
the
into it.
Jawai Chariot stretch.
Yes, my lord.
That is the, just before Ladrimbai.
Yes, and even the Sonapur, the tunnel and all these things, my lord, will take some time, and
You file a report by then, and
we have filed a report, my lord, indicating the reasons, basically the reasons why these
Very well.
roads are getting.
Status reports have been filed both by the state pertaining to the Jawai bypass and by the National Highways Authority of India pertaining to the rest of NH6 between Jawai and Ratachera. Paragraph. Judicial notice is taken of photographs published in Shillong newspapers over the last couple of days indicating the treacherous condition of the Jawai bypass despite the repair work apparently having been completed by the state PWD bracket road. Full stop. Indeed, the petitioner has carried photographs to demonstrate that the repair has not even lasted a couple of days. Full stop. Paragraph. While it is appreciated that bitumen is water soluble and heavy rains may affect the road conditions, yet all this has happened before the monsoon has set in. Full stop. Further, it can be no excuse, particularly given the heavy rains in this part of the country during the monsoon, that the roads will remain unmotorable during the rainy season. Full stop. The repair work has to be undertaken keeping in mind the weather and climatic conditions and the extent of rainfall that the road has to endure. Full stop. Paragraph. Mr. Khan is requested to meet senior officials of the state PWD roads so that the matter can be taken care of before the actual onset of monsoon. Full stop. Paragraph. NHAI says that some of the stretches between Jawai and Clariot need to be repaired. Full stop. Even beyond the Sonapur tunnel requires some repair work. Full stop. According to NHAI, the contract has been issued.
Will be issued.
The contract is about to be issued, and the work will take. Work is expected to be completed by the end of the month.
End of July.
by the end of July. Full stop. It would have been better if the work had been completed prior to the heavy rains setting in. Full stop. However, since it is too late in the day to expect the work to be completed over the next week or so, NHI should ensure that extra care is taken that the repair work undertaken in the midst of rains is not immediately washed away. Full stop. Paragraph. Both NHI and the state should report on the progress on either stretch when the matter appears next week. Give it to next Thursday.
If my lord allows me to point out to one more aspect.
Yes.
My lord, what had happened, one route sometime, my lord, it is in between Ratachera to Malidor.
Yes.
Lordship, more than 40% of the road had been, my lord, carried away by the landslide. It has been past 2 years, Lordship, till now it has not been attended to. I have taken the photograph.
The Minister points out that landslides that have taken place several months back on the Ratachera to
Malidor, Lordship. Malidor.
So Malidor to Ratachera
Lordship.
stretch have not been taken care of yet, if such is the position, NHAI should look into such aspect of the matter and ensure that the debris is cleared and the necessary repair work undertaken at the earliest. Full stop. The highway is a crucial link to the southeastern part of the northeast and has to be maintained in good motorable condition throughout the year. Full stop. Yes, it will appear next Thursday or so.
It's a holiday.
No, whenever it is, Wednesday then.
Item number 2.
This photograph should be placed on record, Lordship.
You've given it to him.
We have given, Lordship.
Next time you give it to us. We
Obliged, Lordship.
What is this about, Mr. Khan?
This is Gasopura, Your Lordship. Gasopura, the coal matter.
Sir?
Coal matter, Your Lordship, Gasopura.
Yes.
Last date they didn't appear, Your Lordship, so the matter was posted for today.
Who is appearing today?
For petitioner, none appeared last date, but they only filed additional affidavit.
Are you appearing?
Lordship,
Yes.
Lordship, I am appearing for the petitioner.
Yes.
Item number 2.
Yes.
Lordship, on last occasion, Lordship, we have filed an additional affidavit, Lordship.
Yes.
Lordship, actually, the respondents are not giving us a reply of the RTI which we have. Lordship,
What RTI questions? This, don't be childish. Now, not responding to RTI today is just not acceptable, Mr. Khan.
Lordship is.
The information after that, you are there to.
actually, Lordship, actually,
When did you raise the RTI queries?
we have only.
He's obtained RTI.
Just find out, madam, if the problem is at our end or at his end.
It's with you, it's with you. Is it your hand?
Lordship,
Yes.
yes, Lordship, actually, we have advised the court that what are the reasons why delays taking place to file the rejoinder. So, Lordship, may accord us some time to get the instructions from the party.
Very
On
well.
next occasion's
The-
Lordship, I will apprise the court.
The petitioner submits that several queries raised under the Right to Information Act, 2005, have not been answered by the state or its agencies. Full stop. Paragraph, it is a hope that the state would take a mature stand in the matter and furnish such information as the petitioner is entitled to receive. Full stop. Paragraph, let the matter stand over for 2 weeks for the petitioner to file a supplementary affidavit, if so advised. Yes.
Item number 3.
Yes.
May I please, Your Lordships. Your Lordships, last time an issue was came up, my lord, the point of determination of office of profit, my lord. My lord, in view of this, I have submitted last time, my lord, that I filed the compilation of authorities, my lord, which I have filed, my lord. My lord,
The issue is not office of profit. The issue is not office of profit. The issue is that if the state grants aid, then the state can impose certain conditions. Whether the imposition of such a condition along with the grant is arbitrary or irrational. It's not an office of profit case. It's only whether the state is granting aid that the state is doing under the state's obligation. Now, the state attaches certain conditions. Some conditions may be give us accounts every 15 days. Another condition may be that none of this money should be spent on picnic. A third condition may be, there should be a certain ratio of students in the educational institution.
within the area of
Exactly.
maintenance of the education.
Local students and things like that.
My lord.
There could be several conditions
My lord.
which have a nexus with the thing is that whether or not the condition set has a nexus with the object or purpose of the institution or the grant that is made by the state.
My lord, my humble submission in this regard,
This
my
is
lord.
not an office of profit case.
My humble submission is this, my lord. My lord, the respondents petitioners are the professors of a government-aided, privately maintained institutions, my lord, education institution, which is exclusively run by the governing body. Their appointments, their removal, their maintenance, in all aspects, were being maintained by the governing body. Now, my lord, the state government, in view of their schemes, in pursuance of their schemes, they used to give the grants, my lord. Now, the notifications or the policy which barred them, even in employees also, not only the professors, my lord, employees of the aided government-aided institutions. Now, they are barred from contesting the election as well as or participating in the election bodies or hold the office of the local bodies. Entirely, it was barred by. Now, my lord, when it is barred, but it has to be, my lord, it has to be seen that whether the respondents have got right to participate in the political parties or office of the local bodies or contest the elections. If those are bars, these are the rights of the rights of the respondents, my lord, until if they are not a government servant. If they are government servant, they have no authority to participate in the politics or in the contest the election. Alright. But if they are not the government servant, then their right to contest the election or participating in the local bodies cannot be barred, my lord. These rights are constitutional rights and the statutory rights also, my lord. So that cannot be barred. By the notification of 21 and the policy of 2018, that particular activities have been
About 6 or something.
Clause 6 and 7 of the Meghalaya Education Code, under the Meghalaya Education Code. That 6 and 7 was previously allowed, my lord.
Subject to permission.
Subject to permission. Subject to taking leave without pay. And that condition is prevailing, my lord, since 1960. And that has been maintaining by the state as well as the institutions. Now, suddenly in the year 2021, my lord, that notification came barring, omitting, deleting those two provisions, my lord, 6 and
Now
7.
let us look into some nitty-gritties. Now let us say that I have been appointed as a professor in history
My lord.
in a government-aided college. Now, when I take leave without pay, you cannot appoint somebody in my place.
With certain period, my lord. With certain period, a contractual can be appointed, my lord. The provision says that if it is long time, up to 5 years, my lord, and it cannot be joined. My lord, if you permit, my lord, I'll read the provisions, my lord.
Yes.
My lord, provision 6 says, my lord, no employee shall offer himself as a candidate for election to a legislative body or for holding office of any political organization except in accordance with the provision of Rule 7. Provided that an employee may seek election as an independent candidate of a panchayat with the previous approval of the managing committee as the case may be, but he shall not be entitled to accept any office thereunder except in accordance with the provisions of Rule 7. Now, Rule 7 says, my lord, any employee desiring to seek election to legislative body or to hold office of any political organization or local body shall be on compulsory leave without pay from the date of filing his nomination till the end of the next academic session or till the termination of the term of his office to which he may be elected. As the case may be, such employee, however, shall not be allowed to retain a lien on his post for a period exceeding 5 years. Now, my lord, here, in this particular case, my lord, the respondent number 1, who has taken the leave and accordingly contested the election and succeeded in the election, my lord. So his term will be for the 5 years.
No, but how did he take leave?
He took the leave from the managing governing body.
By then the rule had been changed.
My lord, that time stay was there by the order of the stay. By the single bench.
Stay does not wash it out. Stay keeps it in suspended animation. Stay does not have the effect of overwriting it.
That was not in force at point of time, my lord, is my humble submission.
Today the rule has been set aside.
Yes, my lord. The notification has been set aside, my lord. Not the rule. That previous rule has been restored, my lord. This rule which I have read, my lord, that is restored, and the notification by which it was omitted were set aside, my lord. That was the position at that point of time. Now, my lord, under the provision of Representation of People Act, my lord, the section 5, may I read, my lord. Even in constitutional provision also is there, my lord. Now, who can be the member of an assembly, my lord, state assembly?
Yes.
My lord, it says section 5, my lord. A person shall not be qualified to be chosen to fill a seat in the legislative assembly of a state unless, number A, in the case of a seat reserved for the scheduled caste or the scheduled tribes of that state, he is a member of any of those castes or those tribes, as the case may be, and is an elector for any assembly constituency in that state. In the case of a seat reserved for an autonomous district of Assam, he is a member of a scheduled tribe of any autonomous district and is an elector for the assembly constituency in which such seat or any other seat is reserved for that district. And in case of any other seat, he is an elector for any assembly constituency in that state, my lord. Already here the respondents belong to the scheduled tribe, my lord. And they acquire the right to contest the election and become the member of the legislative assembly.
So office of profit is not indicated in in section 5.
My lord, it's not indicated. Now, office of profit comes in the provision of, in Constitution of India, my lord. In Constitution of India, although there is no definition has been provided in Constitution of India or any other legislations, my lord, but it has been decided on various tests by the different cases by the Honorable Supreme Court, my lord, as precedent, my lord. But now, in Article 109 of the Constitution of India, my lord, one A, my lord, a person shall be disqualified for being chosen as and for being a member of the Legislative Assembly or Legislative Council of a state if he holds any office of profit under the government of India or the government of any state specified in the first schedule other than an office declared by the legislature of the state by law not to disqualify its holder, my lord. I'm sorry. My lord, here the respondents are not the employee of under the government, either central government or the government of the state government or the union territories or any other organization run by the government, my lord. So since they are not come under the purview of holding the office of the profit, my lord, they have got every right to contest the election.
Which provision did you read?
This 191 Constitution, Article 191 Constitution of India, my lord.
Yes.
Now, in view of this, my lord, the respondents are not holding any office of the profit, my lord, or they are not under any of the employee of the government, my lord, state government or the government of India, my lord. Well, in this regard, my lord, there are certain tests have been made since there was no concrete definition of holding of office of profit, my lord. There are certain tests were made, which, my lord, I have filed in my compilation.
Those are not relevant for the present purpose.
This
191 is disqualification. Disqualification is ex post facto. Just because of 191, why can't certain condition be imposed while granting aid?
That was the condition, my lord, section 6 and rule 6 and 7, my lord. Condition of the permanent leave. And that was restored, my lord. But what is my humble submission that, my lord, by by issuing a notification, my lord, my right to contest the election has been evaded, my lord.
Let us see what the learned single judge says.
My lord.
Learned single judge.
Since page 23, my lord, of the appeal petition. Memorandum of appeal, my lord.
Where is the right to vote and right to contest in the Constitution?
My lord, it's C26.
Mr. Advocate General,
Please, Lordship.
the caveat which is there in 326
Yes, Lordship.
is and is not otherwise disqualified
Yes, Lordship.
under this Constitution or any law made by the appropriate legislature.
Please, Lordship. These are the,
Only the Constitution
yes, Lordship.
and the legislature can make that.
Yes, Lordship.
No one other than that.
Yes, Lordship.
In this case, your legislature has not made it.
Yes, Lordship. Legislature has not made it.
And what are, it says on the ground of non-residence, unsoundness of mind, crime, or corrupt or illegal practice.
Yes, Lordship.
And these are exhaustive.
Yes, Lordship.
So how will your law fit in with this?
Yes, Lordship. There are two aspects, my lord. One is that the petitioner is entitled to contest election, participate and vote, but the restriction which has been placed on him is when he is receiving the maintenance grant from the state, he is not entitled to do it. He can resign from service and he can do it. This restriction, the government has not...
The order that has been passed
Yes, Lordship.
does not entitle him to receive the grant. It only says that he will continue to enjoy leave of absence.
Yes, this was the rules which was in existence before amendment, my lord. This was the rule. By amendment, this rule has been deleted from the rule book, my lord. By deleting it, now the teachers of government aided colleges, while in service, may not be eligible to contest. Now the policy, this policy is also supported by Article 191, my lord, because
That was the previous position was also
the
there.
previous position was there, my lord.
Today you are adding something. You are prohibiting a person from contesting.
When he is in government service.
He is not in government service.
Your lordship, he is akin to the government service.
He is not in government service. He is receiving a salary from funds made available by the government.
And we exercise number of controls also, my lord. Government exercises number, I have placed that rules also in my writ appeal. So for all practical purposes, he is as good as employee of a government.
No.
I can place, my lord, the relevant rules to show that he is, and this test, my lord, whether he is under the hit by office or profit or not, this has already been examined by Honorable Supreme Court in Bihari Lal Dobre, Milord, where a teacher of basic primary school was also declared hit by office or profit, Milord. So therefore, if I draw the parallel.
No. Your previous rule is permissible.
Yes, Lordship, subject to certain conditions.
Your previous rule is permissible, which is that he has to take leave.
Yes, compulsory
He
leave.
cannot draw salary from the government while he is in this.
Yes, Lordship.
And confined to only where office of profit applies.
Yes, Lordship.
You cannot also restrict him in holding political position.
Yes, Lordship. And that too, for that also he is required to take leave, Milord. Leave is, if he is holding a political position also, he is required to take leave, Milord. There also.
Under the old provision also.
Under the old provision also. Because he, as a citizen, he can do one thing, he can contest election and he can hold the post in political parties also. But when he is holding the post or contesting the election, he has to take leave. That was the regime which was prevailing.
Only holding the post
Of a political party, Milord.
that also he would require, he would go on leave.
Yes, Your Lordship, and you see, because the 6 said that he is not entitled.
We are not interfering with what was there.
Yes, Your Lordship.
But here now, what
Yes,
you're doing is, the essence of 191 is that a person drawing salary from the government
Yes, Your Lordship.
should not also be a member of parliament or member of the legislative assembly.
Yes, Your Lordship.
Now you have taken care of that by providing in your old rule that he will be on compulsory leave.
No, when he contested election, Milord, he was drawing salary, Milord. He did not resign from he did not take, when he contested election, Milord, he was drawing salary. So therefore, in my respectful submission, Milord, when he was drawing salary, he will come under this particular legal bar, Milord. Kindly see for that, Milord, because this issue is, there are 2 requirements, that there may not be requirement of master servant, Milord. There has to be post, and post should carry the remuneration.
Is there a corresponding provision for parliament as 191?
Yes, Your Lordship. It is there, 58. I'm sorry, Milord. Where is it?
'84. So office of profit is not there in MP.
Is there, Milord? I have seen some.
And 173 is for the Legislative Assembly, my lord.
Parliament.
Article 173 is for the member of the Legislative Assembly, my lord, of the state. Corresponding provision, my lord.
191 corresponding provision.
173, yes.
102. 102, my lord.
(102) is similar to
191.
is similar to 191.
Yes, Lord.
What does 192 say?
192, my lord, is a provision relating to once the issue has arisen with regard whether a candidate or a member is holding the office of profit or not, my lord, the complaint will go to the governor, who will in turn consult election commission, and thereafter he will render the opinion. Now, learned single judge has also declared this office that the teachers of government aided colleges are not holding the office of profit. This finding, my lord, will also be binding on governor, and that issue cannot be gone into by the governor after this finding, my lord.
No, but what is the effect of 192?
192, my lord, is a situation where a complaint is made against sitting legislature that he is holding office of profit because he is having some,
In spite of having a member of the legislature.
You have been sworn in?
Yes, sir.
Yes, my lord.
Very good. Then you have to abide by 192.
So that decision has to be taken by the governor, my lord, on complaint. On a question raised on the position of the sitting member, my lord.
But the finding has been recorded by learned single judge that it is the respondent is not holding the office of profit.
But no complaint has yet been made.
Your Lordship, in view of the finding, even governor can't proceed because that order of learned single judge is binding on him.
Was the petition filed prior to the election?
Yes, Sir Lordship.
Petition was filed prior to the election.
So, and my case is, my lord, that whether it is a case of office of profit or not, that issue can be gone into by the governor on appropriate complaint being made in this regard. But
then what we will do is, because I was not aware, personally I was not aware of 192.
Yes, Lord.
Now what we will do is, we will keep the order in abeyance, the impugned order in abeyance. If a complaint is made within the next 2 weeks to the governor in accordance with law, then the procedure under 192 will take place uninfluenced by the observations in the order, and you will be entitled to challenge it, or they will be entitled to challenge it in accordance with law. Because now that the situation has arisen,
that plea has not been made, my lord. That plea has not been made in any of the petition. That
is a constitutional requirement. That plea does not have to be made. It's a constitutional requirement. That if any question arises.
Here, my lord, the question as to the office of the profit has not been my lord, that question arises, my lord. Now, my lord, I may be allowed to submit the authorities, my lord, where the respondents.
What we will do is we are keeping it in abeyance. We are allowing that procedure under 192 to take place. And then once that takes place, we'll revive the appeal.
My lord, in that way, my lord, it will affect.
Including, we'll give you a right to challenge that decision in accordance with law.
But in the meantime, my lord, my membership may be disturbed, my lord.
May be disturbed. May be disturbed.
May or may not be that.
It's a possibility is there, my lord.
May be disturbed. We can't give you a blanket because that is the constitutional provision. We cannot override that.
But that question of the membership, my lord, has been decided by a lot of number of cases, my lord. If I am allowed, my lord, number of cases that whether this institute, my lord,
the governor will decide that. The governor in consultation with the election commission will decide that.
My lord,
because this is where it says that this is the decision which has to be made. The court can't step in.
Here, my lord, is a clear provision that if any question arises, my lord, any question of
as to whether a member of a House of Reps has become subject to any disqualification in terms of Article 1 of 191.
That question of the disqualification has not yet been arisen, my lord.
If he holds any office of profit.
Yes, my lord. So here the provision or the situation circumstances of the education institute and the member are clearly indicates, my lord, that there is no office of profit. Now, my lord, the grants which has been receiving by the institute, these grants have been receiving by the institute, my lord, for maintenance of the institute.
No.
Now this entire institute,
They are received for payment of salary. Your salary is included, that's part of the account.
Employees, my lord. That cannot be treated as the government has control over the institute, my lord. Those decisions are there. There are some tests, my lord, whether in numerous decisions, my lord, saying that whether government has the government appoints the person, has got the authority to remove or remuneration or maintenance or any interference on the performance of the office holder. All those tests have been examined, my lord, various judgments. Now, in these judgments, in this arena, my lord, there are judgments that if the test of appointment of the incumbent or removal of the incumbent does by the government, then no tests are required to be examined again. With that only can be done. And if it comes negative, if the government is not either appointing or removing, then they are not be treated as government employee. Yes. They are not holding the office of profit.
Yes. You cite the judgments that you relied on?
Yes, Your Lordship. This 1984, 1 SEC 551, my lord, Bihari Lal Dobre versus Roshan Lal Dobre.
1984?
1984, 1 SEC 551. Then the second judgment.
Just a second.
Para 5, Your Lordship.
Just a second. See, the distinction in this case is that he was an employee of the Board of Basic Education.
Yes, Lordship. Now,
In this case, he does not become an employee of any board.
if your Lordship will see paragraph 5, the test is whether his remuneration is coming from the
There are
government.
many other things. There are many other.
And,
The
yes,
test
Lordship.
is, in order to determine whether he holds an office or appointment, several tests are already applied.
Yes, Lordship.
Such as whether the government makes the appointment. Government
Yes.
does not make the appointment.
All appointments are approved by government.
But the government does not make the appointment.
Yes, Lordship.
Then whether the government whether it has the right to remove or dismiss, no.
Yes, Lordship.
Whether the government pays the remuneration, yes. Whether the functions performed by the holder are carried on by him for the government, no. And whether whether the government has control over the duties and functions, no.
Yes, Lordship. If I can show the rules, my Lord. I have the rules book. I'll show the rules, my Lord. Where the government has extensive control on government-aided colleges, my Lord.
Let us see.
Yes, Lordship. We'll see page 53 of the petition. Page 53, definitions, my Lord. And the name of the rule is Meghalaya Deficit Aided College Management Rules 2013.
Just a second. Deficit aided colleges management
Management Rules 2013.
Yes.
And your Lordship will see section 2A is appointing authority, governing body, my Lord. B, deficit aided colleges means college receiving deficit maintenance grant from the state government.
Yes.
C, DHTE means Director of Higher and Technical Education. D, employee. Employee means every person employed in an educational institution whose entire salary is drawn from maintenance grant received from the state government except menials. That is, all employees covered by grant in aid. So I place emphasis on D, my Lord. Now,
D is for the purpose of the act.
for the purpose of
That
the,
does not make him an employee.
he is not my employee, my Lord, but he
He is referred to in these rules as employee.
yes, Your Lordship. He
That
is
does not make him your employee.
He is not my employee. He is not my employee. What the every deficit college, sir, then Your Lordship, constitution of governing body, if Your Lordship will say, page section 4, rule 4, where rule 4, small Roman 4, then rule 6, my Lord, and then straight away, my Lord,
Rule 4.
rule 4, small Roman 4. 4 members to be nominated by the government, provided the minimum one
Government in the,
is the part of the governing body, my Lord.
what is the total number of persons in the governing body?
My Lord, about 10, or because 2 teachers to be elected, 2 representatives from parents, 1 member from elected donors, 4 members not met, and then principal shall be secretaries, my Lord. So the government has major say, my Lord,
Let us see.
because 4 members are from government,
2 teachers to be elected.
yes, sir.
2 representatives, parents, guardians, 2. 1 member to be elected by donors donating not less than.
So and so.
So this one may not be. 4 members, government. In amalgamated college, not more than 2 additional members in excess of the number prescribed may be nominated by the government. What is an amalgamated college?
Probably earlier, before these colleges came into.
This is not an amalgamated
Yes,
college.
this is not an.
Principal shall be nominated by the joint secretary of the governing body.
Yes, my Lord.
In the event principal being nominated as the secretary, vice principal will be
Joint secretary.
Where is joint secretary? Where is definition of secretary and joint secretary?
It's not there in the rules, my lord. But
So the governing body
consists of 8.
governing body will consist of 9, 8 plus possible 1.
2 teachers, my lord, 2 teachers, 2 representatives, 4. Small Roman 1 and 2 and 3, my lord,
Possible,
and then 4 will be 4 members from the government.
4.
So out of 9, 4 are from
4 are from government, or otherwise out of 8, 4 are from government.
government, my lord. That is,
And they, out of them, will nominate the secretary. If the principal is nominated as a secretary,
Yes,
then the vice principal will be the joint secretary.
yes, my lord. So these are, they will be, and even,
There can be a secretary outside the principal,
yes, my lord,
and otherwise the principal will be the joint secretary.
joint secretary, my lord.
Vice principal will be the joint secretary.
Yes, my lord.
The
And then rule 6, my lord, powers to dissolve.
Now, who will appoint the principal?
The principal will be appointed by the governing body. my lord.
Governing body?
That is there.
So the government does not have total control?
So the governing body consists, at least half of the members are
Maybe.
So the government nominees are appointing the principal. my lord.
Maybe.
So therefore, that is how we exercise control over the principal, my lord.
There are 4.
Yes, I take it, my lord, it is 4, my lord. So if I take it as a 4, whether government has major say in running the
In a 9-member situation, the government will not have control.
the government will,
Nominated. 4 are nominated, my lord.
by government only. So in 9-member situation, certainly government will not have majority in, but the test which your lordship is examining whether government has, and your lordship further provisions I will so regarding the surveys, removal, maintenance.
Let us see.
Yes. The now rule 6, my lord, the power to dissolve governing body of college shall vest with DHET subject to following conditions.
DHET is
Is the director of higher and technical education, my lord. Definition is there
Yes,
in
C.
2C.
Yes.
So the power to dissolve a governing body of college shall vest with DHT subject to following conditions. So the power is also there, my lord.
Yes. Let us see.
Yes. This power will be exercised only in cases of extraordinary circumstances where normal operation and activities of college are disrupted over a significant period of time.
You can't do it arbitrarily.
I can't do it arbitrarily, my lord. That's a crux of rule 6, my lord. And then your lordship will see regarding rule 13, my lord, page 66.
And then, where is the rule that once you nominate a member of a governing body, you can fire him?
So far as, my lord, hiring is concerned, my lord, it will be done by, your lordship will see rule 13.
1-3.
1-3. No, there is a separate rule, but 13 is also. The principal of the college, wherever applicable, shall be nominated by government as ex officio secretary to the.
Where do you have control over your nominated member?
That, my lord, is not mentioned in so many words, but the duties and functions of governing bodies are there, which control, my lord. If you lordship,
in a company situation,
yes, lordship.
in a company situation, I have the right to nominate a director.
Yes, lordship.
My right of nomination is also my right to
recall.
withdraw the nomination.
Yes.
Now you don't have a power to do that, to withdraw the nomination.
If your lordship will,
You have nominated, that person is going to be there for 3 years unless that person vacates office voluntarily. So therefore you have no control over that person in his choice.
yes. Now, kindly see Rule 9, my lord.
Yes.
Ex officio member of the governing body shall be automatically ceased to be member of soon he vacates
That's ex officio.
ex officio. So
That's ex officio. For instance, you name the driver to the
yes, Lord.
so and so minister will be a governing body member.
Yes, Lord. That. Now, Rule 13, I have shown, my lord, that principal of the college, wherever practical, shall be nominated by government as ex officio secretary to the governing body.
We are agreeing with you as far as the previous rule is concerned.
My lord,
Up
yeah.
to that, we will give you the right. More than that,
Yeah, Lordship, kindly
will
see.
be unconstitutional.
Kindly see Rule page 58.
We'll declare the rule ultra vires. If that rule tries to exceed anything more, it's not an act of legislature. It is a rule.
Yes, my lord.
So we will look at these rules. We are the High Court. We'll look at these rules as
Yes,
something
sir.
very menial,
Yes, sir.
very clerical. So we won't attach too much importance
So
to
there
it.
are two aspects, my lord. One, so far as rules are concerned. Second, your lordship will, whether in exercise of power under Article 226, hold that this is not an office of profit at this stage when the issue has not arisen.
Of course.
Yes,
It impinges on a citizen's right to participate.
Yes, your lordship. So then, so far as
It's a much more important question than
yes, I am not doubting
Anything
the
else?
importance of the question. The issue which I am trying to place before your lordship, that there is a mechanism provided in Article 192.
that is your second grade. That's
Second limb.
That's you're adopting my point.
Yes, your lordship.
No,
That's-
no.
No, my lord.
When you complain, we look at it.
But right now, this
The
finding.
matter was instituted before the election.
Yes, your lordship.
Was the writ court right in entertaining? And of course, it was right.
Yes, your lordship.
Once it entertains, it has to answer.
Yes,
It has answered.
Yes, your lordship.
You have participated, and the consequences of the answer are.
Yes, there.
If today there is a 191,
Yes, sir.
a separate opinion may be given,
Yes, your lordship.
and the consequences we look at. But right now,
Yes, your lordship.
there is no 191 has not been invoked.
Yes, your lordship.
192 has not been invoked.
Yes.
So therefore, we will go by this.
So then, the finding of the learned single judge on this aspect that the person
That is not your appeal.
that is not my appeal, my lord,
not your appeal.
but that is not my appeal, but
Your appeal is that this is erroneous.
there are three grounds on which I have come before your lordship. First is that this is a policy decision of the government to regulate by way of executive instruction, which has got limitation.
It's a policy decision which is ultra vires.
Yes, which your lordship is prima facie holding as of now, that it is ultra vires. Now, second is the ground which I have taken, whether the petitioner can challenge the condition of grant,
He is not challenging the condition of grant.
which is not.
He is not challenging the condition of grant. It affects the petitioner.
Yes, my lord. So
It affects the petitioner.
yes, sir.
So therefore, the petitioner has a right. He has a cause of action.
Now there I have a slightly different submission to make, my lord. Now he has a cause of action and in identical situation testing the same rule. Constitution bench held that
Where?
in your lordship the judgment I have cited on last time, and your lordship will see this judgment, State of Assam versus Ajit Kumar Sharma, EIR 1965 SC 1196.
It was cited before the single bench.
No, it was not cited before single judge. Page 897.
Just a second. Come to paragraph 3, end. Look at what was the issue before the court. The last 4 lines of paragraph 3. This resolution of the, before that,
Yes, Milord.
this letter, 4 lines above that, this letter along with another letter was considered by the governing body of the college, and it was resolved that in view of these letters and the resolution of 9th March 62 permitting the respondent to join duties from 6th March could not be given effect to, it was further resolved that the respondent and some other teachers be granted leave in accordance with the rules. This resolution of the governing body was conveyed to the respondent by the principal by letter dated 5th April, and he was told he had been granted compulsory leave with pay till the end of the academic session in view of his standing for election in the last general elections.
Yes, madam. Now,
the respondent thereupon filed the writ petition out of which the president, so his services were not terminated.
yes, madam.
His leave was extended till the end of the academic session.
In terms of the prevailing rule, existing rule.
Not in terms of the government's will.
No, your lordship, rule is same rule. If your lordship will see, the rule is rule 6 and 7. If at paragraph 4, just above paragraph 5, my lord.
And look at the issue, paragraph 4. The respondent thereupon filed the writ petition in the High Court,
Yes, sir.
out of which the present appeal has arisen. His contention was that the rules to which the director had made reference had no statutory force, and
Yes.
that he was entitled to leave under the rules framed by the Guwahati University,
Yes,
which had been accepted by the college.
Yes.
He also, it was in this context
Yes, your lordship.
that the Supreme Court said that the grant-in-aid colleges who receive grant-in-aid will be governed by the rules which are enforced.
Yes,
but the
ma'am.
Supreme Court did not go into the validity of the rules.
Yes, my lord. The issue before this Honorable Supreme Court was, now the question was whether this validity can be questioned by employee
It
of.
can be questioned because he is the person affected by it.
If your lordship will see that paragraph, particularly paragraph 13, my lord. No, paragraph 12, my lord. Sorry.
Paragraph 11.
11.
It seems to us High Court was in error in granting a writ of mandamus against the state, though the director, though one of the rules had no statutory force. And while grants conditions of these grants may be prescribed by statutory rules, there are no law to prevent the state from prescribing conditions such grants by mere executive instructions which shall not have the force of statutory rules. Where such conditions of grant-in-aid are laid down by mere executive, it is open to private college to accept those instructions or not to accept them. Not to accept them would mean not to get the grant.
Yes,
Then,
lordship.
between a government private college concerned, such conditions grant-in-aid cannot. No. This does not canvass what you are saying.
So, and then will.
What you are trying to say is they therefore confer no right on the teachers which would entitle them to maintain a writ petition for the enforcement or non-enforcement of any provision of the rule. The rules are mere administrative instructions, matter between private colleges and government matters in grant-in-aid, and such college, and no teacher of a college has any right under the rules to ask for their enforcement or for their non-enforcement. But not when it affects the teacher. Here is the right of a teacher. That issue was not even considered.
In that case also it was his right, my lord, under rule 7.
That was held between the government.
And after just above paragraph 13, my lord, 10 lines of paragraph 13. Further, it is open to the governing body not to
10
carry.
lines above paragraph.
Fourth line from the top at page, my lord, above paragraph 13, my lord.
Yes.
It is only for the governing body of the college to decide whether to carry out any direction contained in the mere administrative instruction laying down the condition of grant. Further, it is open to the governing.
We follow that.
Yes, my lord.
And
But
what
if
the-
governing body chooses to carry out the instruction, and it could hardly be said that that instruction was being carried out under threat, it is certainly not open to a teacher to insist that governing body should not carry out the instruction. Rules for the purpose of grant in aid being, as in the case, mere executive instruction
You
confer.
must confine yourself to the question.
Yes.
Question is period of leave.
Now,
You are today depriving him of his livelihood.
what I say, my lord, is that he has right to choose.
Just as the government, private college has a right to choose whether it will receive aid or not.
Yes, your lordship, if your lordship will see, just see, kindly see rules again for sake of my lord, rules, page 60, my lord, page 60 of my read.
Yes.
And rule, page 60, my lord, and rule 28. The release of recurring grant is especially meant only for payment of salaries and allowances of teachers falling under deficit grant in aid on the revised UGC pay scale or state scale of pay as the case may. Moreover, teachers falling under this system will be entitled to gratuity at the time of. Now, my lord, why I say with my utmost humble submission, my lord, that the test which is in Bihari Lal Dobre is that whether the person is drawing remuneration from the government or not. The other
any test.
So,
one of the tests.
so then cumulatively, my lord, if this test is clearly established and other tests are also aiding and supplementing, my lord.
No.
We
will go as far as to, even your previous may have been wrong, but we'll go as far as to say that up to there, where the only thing that you do to him, your only connection with him is indirectly you pay his remuneration.
And I lay down certain norms.
You indirectly pay his remuneration. That remuneration he is not entitled to get when he contests in this. Apart from that, no other restriction.
Because that restriction has already been done earlier, he was entitled to leave without pay for the period
For the entire duration.
Yes. Now there will be
entitled to
the
that.
third aspect, my lord.
We will only affirm, as the learned judge he has struck down the amendment, rightly so.
Yes, but at the same time, this learned single judge has also declared that this post is not an office of profit, my lord. Now, kindly.
Which post?
The post held by the teachers of government and college.
We agree with that. That's the basis for the judgment.
And then this is a policy by way of executive instruction, my lord. This policy, my lord, is applied both to the government and to the non-aided colleges, my lord. Now, this policy has some rationale. It may not appeal to me, my lord. It does not have any rationale at all. It may.
Up to the point that you're granting him leave without pay, it has a rationale. Otherwise, it has no rationale.
Yes, Your Lordship. So, what I say is that Your Lordship is fully aware of the scope of judicial review when it comes to the policy and fully conscious of that part.
Policy is not a word that you throw at the court and you say, shut up.
I know that
your understanding of policy is childish.
No, my lord, to that extent I bow down. What I say is that if it has got no nexus with the object it seeks to achieve.
It has no nexus with the object. It has no nexus with the object. We'll embellish the order of the single judge. This is completely arbitrary and draconian.
One judgment, my lord, TMA Pi, only to show that the government has power to put conditions on administration, etc. My lord, that paragraph, if I place with your lordship's kind permission, my lord, that TMA Pi judgment, paragraph 72, my lord, that the citation is, my lord, 2002 8 SSC 481.
How many judges?
It's a 11 judges bench that is relating to, my lord.
Yes, which paragraph?
72. Once aid is granted,
Just a second.
page
72,
page 550, my lord.
page.
550.
Whose judgment is it?
This is probably with Justice Kripal, my lord. He was
550. This is part of the majority judgment.
just part of the majority.
How does this help you?
Only to the limited extent, my lord.
One line.
One line. That the state can impose conditions.
And what conditions can the state impose?
Those are reasonable. The bottom line has to be
And what are they? They are for the benefit of the teachers, non-teachers, and the students.
student, my lord. Now,
Not that to the prejudice of the teachers.
so therefore, the question which falls for your lordship's kind consideration is that whether this policy.
The main thing is, as in the 65 judgment, which is what does office of profit mean? These are members of a legislative assembly who will be making law, who will be deciding on the affairs of the state. The fact that they get remuneration from someone should not influence them in their independent decision making in the house. That is the purpose. That purpose is served by you in ensuring that when they go to contest, they become without pay. So that he does not owe any allegiance to you or otherwise.
This allegiance is broken only temporarily, my lord.
It's broken only temporarily. He has no allegiance to you.
It is broken temporarily.
Actually, you see, you would not make this to stop people of your party. It's intended to stop people of other party.
No, this is for.
It is, yes, you've done it for everyone. But the real intention is to stop your opposition
No, my lord,
from getting people of this
It
quality.
is 2018, this cabinet decision was taken. We didn't know that the teachers.
You may not have known this.
And your lordship.
What, in 2018,
And they are holding political posts also, my lord.
political
So now
post. In
political.
2018, you don't mind, at the time that these executive rules were changed, you don't mind people supporting you coming in. But you did not want people who are in your opposition to come in.
there with greatest respect, my lord. What I say that 2018, my lord. Now, this rule is relating to two aspects, my lord. One, the person contesting the election, and second, person holding the political post also in the parties. Now, and this rule applies, the amendment applies to those both.
Since the challenge is only to the amendment, we will not go behind the amendment. But if the challenge is extended to holding office in political parties, it might also succeed.
But the rule has been struck for both, my lord.
Amendment has been struck down.
Yes, amendment has been struck.
Amendment has been struck down, that's justified.
But now, my lord, the question which I have not raised, that by striking down amendment, whether the original amendment will get revived, my lord, that's a legal issue was there in some of the matters, my lord, whether if it is struck down also, whether the original rule will come into existence.
That is the intention of the thing, or intention of the judgment, by striking it down so that the original position revives.
Whether that's a legal issue which your lordship may take into account while.
Sure, for the judgment.
that have not placed in my appeal, but when I was going through that issue.
Yes, there are. Sometimes it could be, for instance, an act has been repealed.
Yes, sir.
If the repealed act is revived, it's not revived.
Yes, sir.
But when it's a provision which is amended, and particularly not a provision of an act, but the provision of any rules, any delegated legislation, and if the intention of the judgment is that the previous position will revive, then there is no difficulty in that.
Yes, Lord. That's a principle of law.
But then
That's a principle of law, my lord. I can't quarrel with that proposition, my lord. Only last judgment subject to on the issue of, I know lordship's view is very clear.
Just a second, let us take this paragraph 72. State granting aid can impose conditions. Yes.
And subject to your lordship's pleasure, my lord, only one paragraph of on the policy. Policies, I know, my lord. Just one judgment, my lord. This fertilizer, this 1981 1 SEC 568, paragraph 35, my lord.
81 1.
1981 1 SEC 568, paragraph 35.
Not Tarapur.
Not Tarapur. And only 35 middle of the paragraph 35.
Paragraph 35.
35 middle of the paragraph 35. We certainly agree that judicial interference
with a view to the effective policy carried out by the court acting other ombudsman arrangements appropriate emerges. I appeal. Yes, so how does it say anything?
only wisdom, if we have faltered in the wisdom also, my lord, that it says if
I can give you hundreds of better cases on policy than this.
yes, my lord.
Off the cuff, I can give you 100.
Yes, lord.
Which are better on policy than this. This says nothing.
I'll leave it at that, my lord. If only last aspect, my lord, is that the teaching, your lordship is right, your lordship has said that once he joins this the political party or joins the assembly, the post will be vacant, my lord, and temporary appointment will be made, my lord.
Temporary appointment can be
So
made.
then the question, my lord, is that ultimately it will have some impact on the standard of education, my lord.
It may. But
And
then you're testing that against, you're taking away, you see, as long as there is no master-servant relationship,
Now, the law, there is no, and for office of profit, my lord, there is no requirement of master.
there is a requirement.
No, your lordship, kindly see Bihari Lal Dobre once again, my lord. That particularly this line has been there. Paragraph, your lordship will see 5. After 5 lines from paragraph 1, 2, 3, 10 line, my lord. The term office of profit under the government used in above clause, though indeterminate, is an expression of wide import than a post held under government, which is dealt in part 14 of the Constitution. For holding an office of profit under the government, a person need not be in the service of the government, and there need not be any relationship of master and servant between them.
That's in the context. In that case, that is old hat which is now all been obliterated. Previously, government was seen as distinct from any organization set up by the government.
Yes.
That distinction has now been obliterated.
Yes, sir.
Article 12.
12.
Or other authority. That Anadi Mukti Morcha and another
Tiwari, CCMB, my lord, there's
plus NCERT,
Yes, sir.
Pradeep Kumar Sarkar.
Yes.
All those judgments now say that one has to see what is the real substance of the matter.
Yes, Lord.
So if the government has constituted a board of secondary education and the person is an employee of the board of secondary education, in 65, the Supreme Court said not direct master servant. What it meant was not direct master servant. But today we regard it as a master servant relationship. You are employed by a state government undertaking. So you are naturally a state government employee. Just as we apply a reservation to everywhere, not only to government, but also to bodies set up by the government. Reservation applies, equal pay for equal work applies in all cases, unless they are somewhat made different. So there is a direct relationship over here. It's not only your remuneration, it's your appointment is controlled, your severance is controlled, your conditions of service are controlled. Whereas in a government-aided school, what you can do is you can give the standards. You are not making the decision in appointing. You are not making a decision in throwing him out.
Yes, sir.
You have no right to throw him out, you have no right to appoint. Not only that, you only give certain standards which have to be maintained because they are in the interest of the
Teachers
institution and so that your money is spent for the right purpose.
Yes, sir. Those conditions, my lord, if I take your lordship to those conditions, my lord, at page 60 of the writ petition, my lord. Page 60, Rule 28, 29, my lord.
Yes.
Now, 28 I have already placed. 29, a statement of expenditure and income with particulars of details of appointment, approved enrollment, fee income should be submitted with monthly bill for counter signature. Amount of grant for each month shall be calculated according to actual admissibility, amount calculated on the basis of approved expenditure. These are relating to, my lord.
See, there are certain objective criteria over here.
Yes, Lord.
Certain subjective criteria.
Yes, Lord.
The objective criteria all pertain to accounts.
Yes, my lord. And now
look at the subjective criteria coming in.
Yes, Lord.
From 35.
Yes, 35.
The institution shall ensure regular attendance of the teachers, who should stay in the college for a minimum period of 4 hours.
Yes, Lordship.
So you have no, in your college you can say that people should come and stay for at least 7 hours or 8 hours. Over there, you know that you don't have the right,
Right.
so you say at least 4 hours. Then, 36, completely vague. The institution should strive to maintain standards in quality,
Yes, Lord.
nothing objective.
Yes, Lord.
Then 37, no teaching or none shall resort to any kind of unauthorized absence, or if she resorts to from the government shall deduct the pay of unauthorized absence, government is also authorized to do so. This is empowering them.
Yes, Lord.
Nothing else. Refrain from any agitation against the government and its agencies. Again,
That
you
is-
can't enforce it.
You can't.
Can't enforce it. In case of any dispute, forget it. That's nothing.
That is all I have to submit, Bishop.
Yes, we'll start hearing you when? Tomorrow? You've given your compilation, you've given a copy to him also.
I've given already.
Yes, Lord.
Obliged you.
Obliged.
Item number 4.